Tonight's debate asks a deceptively simple question. Whether so-called judge shopping is the act of exposing a real, structural defect in our federal courts or, instead, a corrosive practice that undermines public confidence in judicial integrity. And to test that question we have two figures who represent, in many ways, the poles of the conversation: Judge Edith Jones, a long-serving jurist on the U.S. Court of Appeals for the Fifth Circuit, and Professor Steve Vladeck, a widely read scholar of federal courts and national security law. Before either side makes its case, we should be honest about what we are actually fighting over. Judge shopping is the tactic by which litigants file a suit in a particular division or courthouse because they can reasonably predict the one judge, or the very small set of judges, who will be assigned the case. It is not a new phenomenon. Litigants have always selected venues they think are favorable. But in an era where single judge divisions exist and emergency relief can have nationwide consequences long before appellate review, the strategic choice of filing location can amount to choosing not merely a courtroom but a decision maker, not merely a venue but, for all practical purposes, a verdict in waiting. That is why passions run high. For critics like Professor Vladeck, these structural loopholes let private parties and state attorneys general the federal judiciary into a policy-making shortcut, an end-run-around democratic deliberation and the slow grind of agency process. By converting a courthouse filing into an instant injunction that binds actors far beyond that courthouse's geographic reach. For defenders, including jurists like Judge Jones who stress fidelity to text, structure, and the proper limits of Article 0, what outsiders call shopping may simply be the legitimate exercise of plaintiffs' rights to choose proper venue and to seek lawful relief in a forum that is both available and appropriate. The problem, they suggest, is not partisan gamesmanship, but the rhetoric that presumes bad faith and thereby damages the courts. If we are to debate this well, we must see the moving parts: the allocation of trial, level dockets within districts, the rise of single, judge or tiny panel divisions, the standards for temporary restraining orders and preliminary injunctions, the appellate posture that follows, and, looming over everything, the press cycle and public narrative that amplifies the first order issued and rarely revisits the more nuanced appellate disposition months later. We must also confront the fact that venue choice is part of the litigation toolkit for everyone. Businesses, unions, civil rights groups, states red and blue. So moralizing about the tactic often tracks whether one agrees with this week's plaintiff rather than any neutral principle. And yet there remains a core, nonpartisan worry: if the public comes to believe that outcomes hinge on the courthouse door chosen rather than the law, the legitimacy of the judiciary is imperiled. Because courts have neither the power of the purse nor the sword, they rely on the perception of principled decision-making to command compliance. That legitimacy question is not abstract. The modern federal docket features challenges to executive actions, environmental rules, immigration programs, health care regulations, and technology policies, where a single injunction, issued in haste, can set the terms of national governance for months. When selection effects funnel these cases to predictable judges, we are pushed to ask whether our admirably open court system, anyone may sue, and in many places, has inadvertently created an off-ramp from politics to adjudication, and whether that off-ramp is being used in ways the system never contemplated. At the same time, to call it judge shopping risks framing every chosen venue as cynical and every judge as a mere partisan referee, which is both unfair and corrosive. Judges, including those most frequently identified with these hot-button dockets, operate under rules of evidence, procedure, and appellate review. They write reasoned opinions, they are reversed or affirmed in the ordinary course, and the very visibility of these cases can sharpen their analysis. Thus the question is not whether plaintiffs may pick a lawful forum, they can and will, but whether our current allocation of cases and relief standards invites manipulation that, even if legal, upsets the balance between law and politics. Judge Jones may emphasize that rules exist precisely to channel such choices, and that where reforms are needed, they should come through transparent rulemaking. not rhetorical assaults on the judiciary. Professor Vladeck may counter that the harm is already here. When divisions with one or two judges become the staging ground for national policy fights, the system rewards litigants who can reverse, engineer assignment patterns, and encourages the public to see courts as alternate legislatures. The task before us is to separate heat from light, to acknowledge the rights of litigants without denying the reality of incentives, and to remember that the ultimate issue is not who wins the next injunction, but whether the courts remain, in the public imagination, places where reasons rather than routes determine results.
To argue that judge shopping exposes a real problem is to begin with first principles about how adjudication is supposed to work. Parties bring claims. A neutral decision-maker applies law to facts. Relief is tailored to the case and tempered by institutional humility, and the process, if imperfect, earns trust because the decision-maker is not chosen by either side. When plaintiffs can reliably select the human being who will hear the case by selecting a particular courthouse, the appearance of neutrality is compromised at step one. That appearance matters both because due process demands it and because public acceptance of hard cases depends on it. Consider the incentives created by single judge divisions or places where two judges receive nearly all the civil filings. A sophisticated litigant can study prior opinions, identify methodological leanings, and anticipate how emergency relief standards will be applied. That is not science fiction. It is litigation strategy 101. The problem intensifies in the age of nationwide or universally scoped injunctions and administrative law battles. A district judge evaluating a preliminary injunction may be asked, on a compressed record, to freeze a federal rule that touches millions, with the inevitable reality that the first ruling sets the frame for months while appeals proceed. If plaintiffs can place that first ruling into the hands of a known decider, the systemic risk is clear. Lawyering skill becomes indistinguishable from judge selection, and the appellate process, though it may correct errors, cannot fully reverse the political and social effects that flow from the initial headline driving order. Moreover, asymmetric venue structures can distort the development of law itself. When early challenges funnel into a narrow geographic pipeline, appellate courts receive a disproportionate share of emergency appeals from the same handful of district judges, which not only strains the shadow docket, but also risks creating doctrinal whiplash as panels race to manage nationwide impacts without the benefit of percolation across multiple districts. Add to that the feedback loop with media narratives and fundraising ecosystems. Advocacy groups have every incentive to litigate where they can generate quick wins, publicize those victories, and leverage them into additional suits. Opposing groups, seeing the same structural asymmetry, may feel compelled to respond in kind by filing in their own favored divisions or by racing to courthouse to secure the first order. None of this indicts any particular judge's integrity. It indicts a design that unintentionally rewards strategic filing. And the harms are not purely optical. Resource allocation within the judiciary is finite. When a small set of divisions becomes a destination for national policy fights, those judges' dockets are saturated with emergency motions, sprawling administrative records, potentially crowding out routine criminal and civil cases that deserve timely adjudication. Communities then experience justice delayed not for principled reasons, but because national actors have chosen their courthouse as a battleground. Beyond docket pressure lies federalism and separation of powers. Ubiquitous, rapidly issued injunctions can destabilize the constitutional dialogue among Congress, the executive, and the states, not because judicial review is illegitimate, far from it, but because the pathway of review is being gamed at the front end. Critics like Professor Vladeck therefore argue for reforms that target structure, not outcomes, randomizing case assignment across a whole district rather than within a single division, publishing transparent assignment statistics, encouraging, by rule or statute, more modest geographic scope for preliminary relief, and fostering genuine doctrinal percolation before nationwide remedies are considered. These are not attacks on judges. They are guardrails that reduce litigant leverage over judge selection, while preserving everyone's right to a lawful forum. Even defenders of the status quo should be able to acknowledge that where assignment odds are 100% for a single judge, the appearance problem is acute. Some will respond that venue shopping is as old as the Republic and that plaintiffs routinely seek friendly law. From patent plaintiffs flocking to historically fast dockets to civil rights group filing where precedent is favorable, that is true, but it mistakes law shopping for judge shopping. Choosing a circuit because its precedents align with your theory is different in kind from choosing a division because it guarantees a particular jurist. The former invites reasoned disagreement among panels and gradual synthesis by the Supreme Court. The latter transforms adjudication into selection. To the extent Judge Jones and those of like mind worry that reform rhetoric paints targets on the backs of individual judges, the answer is to focus the critique on architecture rather than actors. When rules eliminate single, judge funnels, when assignment is genuinely random across a district, when preliminary relief is calibrated to the plaintiff's injury rather than to national policy preferences, the temperature falls and the incentives realign. In short, if our goal is to restore the intuitive fairness that citizens feel when they enter a courtroom, then addressing judge shopping is not a partisan crusade, but a maintenance task for rule of law itself. It makes the system more resilient, more legitimate, and more capable of absorbing the next wave of high-stakes cases without sacrificing the very neutrality that gives courts their authority. Now let me pivot to the other side of the ledger, the case you might hear from Judge Edith Jones and those who share her institutional vantage point, because if this debate is going to be honest, it must articulate the strongest defense of current practice, not a straw man. The defense begins with constitutional bedrock. Article Roman 3 courts exist to hear cases and controversies brought by real parties under law. They are not roving commissions that self-initiate disputes in pursuit of abstract balance. Because courts are reactive, not proactive, the system has always left a great deal of initiative to plaintiffs, initiative about which claims to bring, which defendants to sue, and, critically, where to file within the boundaries Congress and the Judicial Conference have drawn. Venue statutes are public, jurisdictional rules are published, divisional structures are voted on by local rulemaking bodies, and assignment protocols are matters of administrative governance, not clandestine games. To call a plaintiff's reliance on those published, democratically visible pathways judge shopping, the argument goes, is to denigrate ordinary litigation strategy and to smuggle into the conversation an expectation that parties must handicap themselves to appease public relations concerns. If Congress has permitted single judge divisions, or if a district has, for docket management reasons, routed certain case types to particular divisions, then the political branches and the judiciary together have already balanced the administrability costs and benefits. It is not a litigant's job to engineer those choices. It is the litigant's right to use them. Moreover, the defense continues, the insinuation that choosing a courthouse is choosing a judge underestimates how the system actually corrects itself. District judges are bound by Supreme Court and circuit precedent, constrained by the federal rules, and policed by deferential but real standards of review. The appellate process is not an afterthought, it is the design. Preliminary injunctions can be stayed, mandamus can be sought, interlocutory appeals, while limited, exist, and the Supreme Court's emergency docket, for all the debate it inspires, is a safety valve through which obviously unbalanced orders can be quickly altered. The fact that the first, in time order, receives media, oxygen, does not mean the judiciary has endorsed the permanence of that order. It means only that journalism runs faster than appellate procedure, which is not a reason to alter the procedure. In this telling, what critics label a structural loophole is better understood as a predictable feature of federalism and decentralization. A large republic with dispersed trial courts will inevitably generate localized filing incentives, and that dispersion is a virtue because it allows legal theories to mature in different forums and permits communities to have proximate access to federal adjudication. Consolidating assignment across entire districts, especially in vast states, might cure a headline, but at the expense of access to justice for litigants and witnesses who should not be forced to travel hundreds of miles for a preliminary hearing simply to satisfy an abstraction about optics. There is also a prudential caution here. From a judge's perspective, the rhetoric of judge shopping risks personalizing what should remain institutional. Judges do not recruit cases. They do not control who files in their courthouse. They take oaths and follow law, and they publish opinions that are reasoned, signed, and subject to review. To suggest that repeated appearances of similar cases before the same judge is proof of bias is to invert the burden of proof, turning normal docket realities into evidence of wrongdoing. The better path, defenders say, is to discipline the conversation around standards. What is the legal threshold for irreparable harm? What is the correct reading of the Administrative Procedure Act's arbitrary and capricious standard? When is universal relief appropriate under Article Roman III and equitable principles? If a particular judge consistently applies these standards in ways one disagrees with, the remedy is not to attack the judge or to stigmatize litigants who file there, but to persuade higher courts to refine the law. Indeed, critics of reform point out that many of the most ballyhooed judge shopping controversies have ultimately produced appellate opinions, sometimes affirmances, sometimes reversals, that clarified doctrine precisely because a concrete case reached review quickly. That is how common law evolves, nor is it obvious, they add, that district-wide randomization is a panacea. Randomization at too broad a level can generate its own inequities. Specialized local knowledge is lost, related case principles are undermined, complex administrative records land on docket already overwhelmed, and parties, especially small businesses, criminal defendants, and civil rights plaintiffs, bear travel and delay costs imposed not by justice but by process engineering. The goal should be a judiciary that is both fair and usable. A regime that prizes only the former will paradoxically deliver less of both, because litigants who cannot practically access a forum will lose faith in the very system that claims to protect neutrality. Defenders also make a subtler point about symmetry and selective outrage. Every ideological community has used venue and division choices to its advantage. Patent plaintiffs once concentrated in famously rapid rocket dockets. Civil rights organizations file where precedent favors their claims. Environmental groups and industry challengers alike pick circuits known for doctrinal leanings to inflate today's divisional filing patterns into unprecedented scandal risks, historical amnesia. What has changed, they suggest, is not the existence of strategic filing but the saturation of national policy fights in the trial courts and the amplification of those fights by social media, which pressure cook what used to be technical disputes over administrative records into existential referenda on governance. The temptation, then, is to grab the loudest lever assignment reform and yank. But prudence urges calibration. If the real problem is the proliferation of universally scoped injunctions at an early stage, address remedy scope. If the real problem is compressed, appellate timelines on matters of national import, bolster expedited appeals. If the real problem is inconsistent emergency standards, clarify them either by rule or by Supreme Court guidance. Altering who gets assigned a case is the crudest intervention, one that risks signaling that we distrust our judges' capacity for impartiality. Judges, after all, are selected, confirmed, and sworn precisely because we believe they can decide fairly even when they hold jurisprudential commitments. To redesign the assignment system around the fear that one judge will be too predictable is to edge toward a world in which neutrality is equated with methodological agnosticism, a standard no jurist could meet and no litigant actually wants. Litigants want reasons they can understand and rulings they can appeal. They do not need roulette wheels to feel heard. Finally, the defense contends that reformers underestimate the disciplining power of transparency already present. Docket statistics are public, opinions are published, stays and reversals are counted, and repeat filings in a division are visible to everyone from the press to Congress. If structural manipulation were truly corrupting outcomes, one would expect durable empirical patterns of misapplication reversed at extraordinary rates. What we actually see, defenders argue, is messier and more normal. Some early orders stand, others fall. Some judges become magnets for certain case types because lawyers believe those judges read the law in a particular way. Appellate courts arbitrate, and the Supreme Court, when necessary, settles the split. This is not evidence of institutional failure. It is evidence of a plural, distributed judiciary functioning under strain. And because it functions under strain, caution is warranted before layering on new rules that may have unintended consequences for access, speed, and the ability of trial courts to manage their caseloads. Reform, if adopted, should proceed incrementally via local rulemaking with input from the bench and bar, rather than via sweeping national edicts issued in response to the scandal cycle. The legitimacy of courts, on this view, derives less from eliminating every avenue for strategic filing, which is impossible, than from maintaining a culture where judges decide under law, explain themselves in writing, and accept correction without drama. In short, what critics deride as judge shopping may often be the predictable byproduct of a large, open, and rule-bound judicial system, a system that already contains the tools to diagnose and correct genuine abuse without recoding its fundamental architecture. So where does that leave us in tonight's Showdown? Professor Vladeck's alarm about litigant, controlled assignment versus Judge Jones's insistence that law, process, and appellate review are the appropriate correctives. It leaves us, I submit, in a posture that good institutional design often requires, reconciling legitimate, competing goods. We want plaintiffs to have meaningful control over their lawsuits, including the ability to file where witnesses live, where harms are felt, and where law is favorable. We also want the public to trust that no one can all but appoint their judge for a case with national stakes. We want trial courts nimble enough to halt unlawful government action before it inflicts irreparable harm. We also want preliminary relief tailored to the parties rather than to the nation absent a developed record. We want local access to federal justice. We also want randomization robust enough to assure the appearance of neutrality. Achieving these goods together demands more carpentry than poetry, targeted joints and braces rather than sledgehammers. Start with assignment. The goal is not to abolish divisions or to erase local expertise, but to dilute predictability at the extremes. Districts that currently guarantee assignment to a single judge for broad swaths of civil filings can adopt district-wide randomization for cases seeking statewide or nationwide relief, while preserving divisional assignment for routine matters. Publish the algorithm. Publish quarterly the distribution data by division and case type so the bar and public can see whether the randomization is functioning. Pair that with transparent related, case rules that prevent gamesmanship without punishing efficiency. If a new case is materially related to an earlier one, it can be assigned to the same judge, but only after a publicly docketed finding of relatedness, with an avenue for objection and review by the chief judge. None of this impugns any individual jurist. It signals a system confident enough to open its mechanics to daylight. Next, recalibrate emergency relief. Without denying any court the power to issue nationwide injunctions when law and equity require, we can refine presumptions that discourage universal scope at the preliminary stage absent a developed record and specific findings, a presumption favoring party-specific relief, a requirement to articulate why narrower remedies are insufficient, an expectation of expedited merit proceedings when broader relief is entered, and a strong bias for coordinated, consolidated appellate review where simultaneous nationwide impacts are likely. This approach attends to what truly fuels the judge shopping narrative, the outsized consequences of first-mover preliminary orders without stripping courts of their ultimate equitable authority. Complement that with structural supports for speed and quality, expand availability of rapid merits, focused hearings within 60-90 days for cases presenting national questions, resource district courts with specialized clerks for administrative record review, and encourage circuits to adopt internal procedures for accelerated, reasoned stays that lower the temperature while preserving appellate deliberation. If the criticism is that journalism outruns appeals, the answer is not to muzzle journalism, but to speed the law. Third, invest in information and norms. A great deal of suspicion surrounding judge selection blossoms in the absence of shared facts. The Judicial Conference, working with district courts, can maintain a public dashboard of case assignment practices, divisional structures, and filing statistics, updated on a cadence that keeps pace with modern news cycles. Law schools and bar associations can teach the distinction between venue choice, division selection, and judge assignment, clarifying for students, reporters, and citizens how much is strategy and how much is structure. Judges themselves, consistent with ethics constraints, can write more explicitly about scope of relief choices in preliminary orders, situating those choices within the history of equity and limits of Article Roman III. This is not window dressing. It is the daily work of legitimization that democratic institutions must do in an information-saturated era. When the public can see the gears, when they can read a lucid explanation of why relief is broad or narrow, why assignment landed as it did, why a stay was granted, they are more likely to accept the outcome even when they disagree. Fourth, remember symmetry. Any reform we adopt will be used by litigants of every ideological stripe. That is an argument for neutrality. Write the rule you would accept if your adversary held the pen. If a district-wide randomizer blunts your favored filing strategy tomorrow, can you still look a client in the eye and say the forum is fair? If an injunctions scope presumption slows your policy preferences today, will you be glad for it when the shoe is on the other foot? The genius of procedural design is not that it eliminates strategy, but that it channels it into pathways that enhance rather than erode legitimacy. And legitimacy is the currency our courts cannot print on demand. Absent armies and treasuries, courts command compliance because they persuade through reasons, through restraint, through habits of fairness that accrete over years. That is why this debate matters beyond the week's controversy. A public convinced that the identity of the trial judge determines the fate of national policy will not long tolerate judicial review. It will see courts as proxies for political tribes and treat their rulings accordingly. Conversely, a public that observes a system transparently attempting to reduce predictable funnels, to justify extraordinary relief, and to speed appellate correction will extend the benefit of doubt the next time a hard order issues. In closing, then, I would cast tonight's proposition not as an indictment of judges or of litigants, but as a maintenance protocol for a 21st century judiciary operating under extraordinary load. Professor Vladeck is right to warn that highly predictable assignment in single judge divisions, married to the explosive potential of nationwide preliminary injunctions, creates incentives that can warp both perception and policy. Judge Jones is right to remind us that courts are rule-bound institutions with built-in correctives, and that the cure for a bad argument is a better one, not campaign to delegitimize a colleague. The synthesis is straightforward. Preserve litigant choice and local access. Thicken randomization where predictability is total. Trim the sails on early universal relief. Accelerate pathways, reasoned appellate review, and radically expand transparency so that the public can see not only what the courts decide, but how and why. If we can do that, if we can marry humility to courage, tradition to experimentation, we will have answered the opening question. We will have shown that exposing real structural tensions need not undermine judicial integrity. It can fortify it. The path to that fortification lies not in warring caricatures, but in cooperative craftsmanship, judges, scholars, lawyers, and legislators building, step by careful step, a system that remains worthy of voluntary obedience even when it hands each of us, as it inevitably will, our share of defeats.